Welcome to Looking at Legal Stuff. Today we have part 2 of a case with a couple where dad took the child and removed him from mom's care after their son told his father that he was afraid of mom's boyfriend. He was granted restraining orders against both mom and the boyfriend, but despite the restraining order allowing mom to have supervised visits, mom has not really seen the child in the last 8 months because she refuses to allow dad's family to supervise. Dad wants continued supervised visitation, but mom wants 50-50 custody, so they're going to have a trial to establish a parenting plan. We'll hear tons of accusations thrown around at the trial, including drama with dad's divorce from his current wife, DV, substance abuse, cheating, toxic family members, and so much more. Will the judge agree that mom needs supervised visitation because of her boyfriend? Let's find out. The first 2 hearings can be found in part 1 of this case, and that video consists of their full 5-hour trial. You'll want to watch the trial first before you watch these 18 review hearings to fully understand what is happening in part 2. I'll link it for you down below.
You're anticipating Mr. Miller being present today?
I am not, and I just want to point out that on the docket, this is listed as a recusal, and the order I believe that we had filed with the court was for a modification of child support.
Okay. Just double checking the recusal. I looked at it yesterday. It looks like it was Commissioner Nelson based on involvement in a mandatory settlement conference. Yeah, and the clerk mentions that it's just a flag there to give everybody notice.
Okay.
Not necessarily on
I just wanted to clarify that. Thank you.
Yeah, that's great. Okay, so let me double check. So it's on for child support. It looks like Ms. Amasquita was served, and Ms. Amasquita provided documentation as far as taxes from 2022 and gave some detail about mortgage and costs and expenses. And then what I didn't see, and maybe let me just pull it up here. What I didn't see, and maybe I missed it, is information as far as financials from Mr. Miller. So let me check with Ms. Holder to see if I've missed something, or if documents were filed.
No, Your Honor, you haven't missed anything. I believe because it was listed on we saw it on the docket from my office as the recusal, it got through the cracks, and so we were not able to respond after our initial motion. So I don't know if the court would like to set this matter over to get that information, or if you would be okay being heard based on the information that is just in Ms. Amasquita's motion or her response.
Okay. Well, my initial sense is it's probably fair to all parties to have all the information that's going to be presented to the court at the hearing. Ms. Amasquita hasn't seen the information from Mr. Miller, so it strikes me as it would seem more equitable to have everybody have the same information, and from that present their cases with that in mind. So my preference would be to set it over 2 weeks to the 25th, so everybody can have a look at all the information that's on the table. And let me check with Ms. Amasquita if we were to set this over 2 weeks, and then that would allow you to look at Mr. Miller's information and be better prepared for the hearing. Do you have any concerns with that?
Is that for me or Ms. Amasquita?
Not for Ms.
I do not have any concerns with that.
Okay.
No, I'm fine. Just setting it over.
Okay, so you're fine, Ms. Amasquita, setting it over to the 25th of July?
Yeah, that's fine.
Okay, well, let's do that. We'll get those financials from Mr. Miller, and we'll be in a better position to address that. So we will see everybody on the 20th.
Your Honor, if we could address number 7 on the docket, Miller versus Amasquita.
Sure. This is cause 22-3-528. Ms. Holder's here representing Mr. Miller, and we'll check to see if Angel Amasquita is on the line. Ms. Amasquita, if you're here, if you'll...
Yep, I'm here.
Okay, great. Welcome to you. All right, let me just pull up my notes.
Your Honor, we had set this one over because Mr. Miller had not gotten Ms. Amasquita the documents, the financial documents that were needed to correctly assess child support. At this time, he is still having difficulty getting the necessary financial documents, and I would ask that we have one more set over on this.
Okay, Ms. Amasquita, do you have a position on that request?
Sorry, my baby's in the background. I've been waiting for documents, and I hate pushing this out more. And I know in another, like with the beginning when we had the trial, she didn't provide they didn't provide me documents until the day of the trial. And then I just feel like they're pushing it out as far as they can. I just really would like to not keep pushing it off. Cause I left work early so I could be up in time for court, and I hate missing work because of court.
Right, right. So
Your Honor, may I respond?
you can.
Okay. First of all, the trial was on a very shortened timeline. I was retained within 2 weeks of trial. And the second matter of wanting to push this out, we do not want to keep pushing this out, as Mr. Miller is the one who is going to be receiving child support. He is the one who would be have a detrimental impact, not Ms. Miller, when it comes to receiving money. So we are not trying to push it out. We are trying to get the necessary documents. I have some. I do not have all, and I wanted to provide the court with as many documents as possible to come to a determination when we are seen next.
Okay, thank you. Well, it's interesting because it looks like there was service upon Ms. Amasquita back on June 15th. And then Ms. Amasquita responded and supplied W-2s and other declarations related to her expenses. What was odd is that Mr. Miller, the moving party, didn't supply any financial information upon the initial filing, which just kind of strikes me as odd. And now there's a continued request to, I think this is our second time to address this. So I'm just a little bit confused why that supporting documentation wasn't included in the initial pleading.
Your Honor, he had switched jobs, and he is still trying to get his last paycheck from his last job and documents from his last job that go toward the child support order. And he has gotten us some things, but he hasn't gotten us what we've requested, which would be the paycheck stubs. He's gotten some financial documents, but I don't believe that it is enough. And so we have kind of sent him on a scavenger hunt to go find it from a job that's not exactly responding to him very well.
Okay. Just double check. So we were here back on July 11th, and it was continued at that time. I'm going to award $250 of costs that Mr. Miller will need to pay to Ms. Amasquita for the lack of documentation and the waste of her time on 2 separate occasions. So we'll set it over to, does 1 week give you enough time?
Yes, Your Honor. Thank you.
All right, we'll set it over 1 week, and that'll be on August 1st at 9 a.m. And we'll see everybody then. I'm going to just draft and bench order right now as far as the costs. But just so the parties can hear what I wrote. Petitioner shall pay $250 to respondent for repeated set overs based on petitioner's failure to provide financial information. This payment shall be made within 30 days. So we'll file that, and we'll see everybody next week.
All right. Thank you, Your Honor.
Great, thank you. Joining us today.
He is not, Your Honor.
Great, thank you. Welcome to you, Ms. Holder. And Ms. Amasquita, can you hear me?
Yeah, I can hear you.
All right, very good. Welcome to you also. Today we're noted up for a hearing. Pardon me. Let me just get my notes here. We're here on a motion related to Mr. Miller's motion related to child support. And so let me just double check with Ms. Miller. When I checked the file yesterday in preparing the docket, I didn't see any new filings related to the child support contempt. Were any filed since the last time we were here?
Yes, Your Honor. Something was filed yesterday afternoon. It is a declaration from Michael Miller on top of child support worksheets, as well as paycheck stubs from Mr. Miller.
Okay.
And those were also sent to Ms. Amasquita.
All right. So that was yesterday that they were filed, you said?
Correct, Your Honor. My client was finally able to get a hold of some of his documents.
Okay. So I obviously those haven't made it to the system, and so I'm not able to review those. And we've spent another, at least Ms. Amasquita spent another hour, kind of like the last time we were here waiting.
I also want to point out there's some errors in the paperwork that was filed. They misspelled and added Miller to my name, and I don't have that in my name.
Okay. All right. Thanks for that. So I don't think we can do anything today because I haven't reviewed the materials that were submitted by Mr. Miller late yesterday, and I'm assuming Ms. Amesquita hasn't reviewed them either. So, and hasn't had an opportunity to respond. So if we were to set it over again, and again, I think this is, it looks like there was on July 11th, we didn't have any financial information supporting of the allegation of the child support issue. On the 25th, they imposed a $250 attorney fee against Mr. Miller because we still didn't have financials. And as of today, they're still not in the file. I mean, they're in process. So Ms. Holder, you could maybe explain your client's position, why I shouldn't add additional fees.
My client was still, sorry, thank you, Your Honor. My client was still in the process of trying to get those additional paycheck stubs. He was, for whatever reason, his employer has been rather combative in getting him information. He has not filed his taxes from this past year because he is in the process of going through a divorce. And so he didn't have any tax documents filed. And so that was unavailable to us. And he is one of the reasons that he is asking for child support is his wages have been cut. Excuse me, not his wages, his hours have been cut at his job. So he is not making the same amount of money. Previously, he was making exactly $100 a month too much for state assistance. Since he has had those hours cut, I have advised him and encouraged him to get a hold of some form of state assistance by applying. He's been on the phone during his work hours or his non-work hours, and he has not been able to go to the office to do that because he is not only responsible for his son with Miss Amesquita, but he is currently involved in dealing with another child from the child that he has with the woman he is going through divorce from. So he has found it rather difficult timing wise and financially. He's been scraping money together to be able to pay for gas because his wife or his espoused wife, estranged wife, has moved up to Olympia. And so that's why the timing has been off, is anytime that he's not working, when he hasn't had his hours cut, he has been traveling back and forth to Olympia to exchange the child with his current, his estranged wife. So it's just been an issue of he hasn't had the money, he hasn't had the time, he's been scraping to try to make ends meet. And it is partly my fault, Your Honor. I will be honest, I have been extremely booked with hearings, and when I have been able to call him, he has not been available. And when I've reached out to him, he's been unavailable due to these timing issues. And so I will take part of the responsibility for that, Your Honor, and I do apologize.
Thank you. Ms. Amesquita, I think last time you had mentioned that you took time off work. Is that correct?
Yeah, and I did warn my work. I did have court today. I didn't leave early, so I actually have been staying up since been off work to have court because I didn't know how long it was going to take.
Okay. So did you say you're at work, but you're like taking a break? Is that?
No. I was off work at 7 a.m.
Oh, I see what you're saying. I see what you're saying. Okay.
Yeah.
All right. So I think given those explanations and with those financials being filed, that will allow Ms. Amesquita to reply, file something if she'd like to in response. And then that will allow us time on August 15th at 9 a.m. if everyone's available August 15th to address these. Yes, go ahead.
We do have a update for the whole entire case on the 8th with the judge we had for our trial.
Oh, and was that date previously set, I'm assuming?
Yes, it was an update to see if we had everything turned in that we needed. I know everything that I needed turned in got turned in.
Yes, Your Honor. Ms. Amesquita is correct. It's a review hearing based on the orders that the judge gave. It was to see if all the paperwork had been filed from the parenthood classes as well as the domestic violence evaluations from all three parents involved.
Gotcha. Great. Yeah, thank you. Thank you for reminding me that August 8th at 1 p.m. in front of Judge Fassett to review those issues. So I think we'll probably just need to set it to the 15th also at 9 a.m. to hear the motion related to contempt on the child support. So Ms. Amesquita, you've got those documents. There's the allegation made by Mr. Miller. If you want to respond to that and have your vantage point heard, you'll need to file something with us. So and I know you've already filed some other things, but if you have additional, you can file more.
Okay.
All right. So we'll see everybody August 15th at 9 a.m.
Thank you, Your Honor.
Okay. That sounds great. We'll see everybody then. Thank you.
Thank you.
All right, Miller and Amaskita, 22300528808.
Good afternoon, Your Honor.
Good afternoon. And I saw Miss Amaskita here. Okay, so I'm really confused about what's going on here because I see this case has been in front of Judge Evans several times since we were last here for temporary orders when I thought I had entered some pretty explicit directions thus far. So that's my first question. Second question is it appears Miss Amaskita has done everything that was requested of her, and there's been nothing filed by Mr. Miller. So Ms. Holder, if you want to answer those questions for me, I'd greatly appreciate it.
Yes, Your Honor. We were in front of Judge Evans for a modification of the parenting plan regarding child custody payments or child support payments, as there has been no payments from Ms. Amaskita, despite the fact that Mr. Miller has had full custody of the child since October. So that was what that was in regards to. There has been no child support between the parties at all for the entire pendency of this case. So that was why that was done.
All right. And why is there nothing filed on Mr. Miller's behalf for domestic violence evaluation?
That is my fault, Your Honor. I do have Mr. Miller's assessments, and I've actually just signed the submissions right now, and my paralegal is submitting those to the court as we speak. So that is my my error. I have not seen Miss Amaskita's, what she has filed. She sent things to me that was just a cover sheet. So I was not aware that Miss Amaskita had filed with the court. And it was my understanding, based on what Miss Amaskita had said in the motion for a temporary family law order modification, that no one had filed anything as they were waiting for all the parties to exchange before they decided to file, and they weren't going to file anything until they had seen Mr. Miller's, and we had just finished that, and it was signed off on July 24th.
And I have that she filed her domestic violence evaluation July 5th.
Okay, my apologies again, I did not see that.
Index 35. I don't know if Miss Amaskita, did you serve?
Yes, I
Holder?
emailed everything to his attorney. Mine got done, and then the lady said she had to wait to complete Mike's, and because of Michael's, and all that debt was done on July 20th.
So Mr. Chaddock's was done on the 20th?
Yes, and I filed his with all the child support stuff.
Yes, Your Honor, and Ms. Amaskita is correct. That was also filed because Mr. Chaddock attempted to have the DVPO dropped, and it was also filed in that case. And that is how I saw his DV assessment.
Okay, so Miss Amaskita, have you been able to have your visitations?
I have, this last week, I haven't seen my son because I had COVID.
Oh, I'm sorry to hear that. I hope you're okay.
It's been hard for me to get a hold of Michael because he wasn't paying for the app because he couldn't afford to pay it for this month. So I've been trying to talk to his mom about visits and calls. And I did let her know that I had COVID and I should be fine to see him sometime this week.
Okay, but other than your illness and the app not being reliable, you've been able to have your visitations all summer?
Yes.
Okay. Ultimately, I mean, I obviously I would like to see Mr. Miller's evaluation. Ms. Holder, you're in a unique position where there may be a opportunity for you to negotiate some potential resolution here. For him, his stuff to get filed and to set a review out. If we keep everything status quo, do you think 2 or 3 weeks would be ideal to review this?
Your Honor, we can do it in 2 weeks. That would be appropriate.
Okay. So if you're filing those this week, I'll look for those so I can come up with something. My hope would be, assuming that I get everything timely filed, I'll have a parenting plan drawn up for the 22nd. So, Ms. Amaskita, I hope you are feeling well soon, and you can get your visitation started back up, and then we will come back on the 22nd of August at 1:00 p.m. And I'm going to say it's for review. My hope is that we'll be able to enter a final parenting plan at that point. All right.
Thank you, Your Honor.
All right. Thank you.
Okay, thank you.
And I believe it's pronounced Amaskita.
Yeah, I'm here.
All right. So Ms. Holder, go ahead.
Your Honor, we're here to modify the parenting plan to include child support. Mr. Miller has had custody of their son since October of 2022 due to removing their son from Ms. Amaskita's home because he had gotten a restraining order against Ms. Amaskita's partner, Mike Chaddock. And Ms. Amaskita currently has supervised visitations, but she still lives with the father of the other two children, Mr. Chaddock, who again still has that DVP against him. On July 31st, Mr. Chaddock attempted to have the DVPO lifted in front of Commissioner Carney, but there was no chance of circumstance and there was no adequate cause to drop the DVPO. As a result, it is going to drop in December as an operation of law. And so that DVPO is still in place. And Ms. Amaskita also has a DVPO in place because of Mr. Chaddock's DVPO. Ms. Amaskita went and picked up her and Michael Miller's son at school immediately after he dropped him off. And there is concern that Ms. Amaskita would expose and take Buddy, Mr. Miller, and Ms. Amaskita's child in front of and to the home where Mr. Chaddock is. At that hearing on the 31st, where the DVPO was denied, dismissing it was denied, Commissioner Carney noted it appears Mr. Chaddock still doesn't know why a DVPO was originally granted. He isn't taking responsibilities for his actions. He doesn't even know what domestic violence is, and he needs 6 months of DV classes to complete those. Ms. Amaskita still believes that she is not a victim of domestic violence. And so it is unlikely at this time that she is going to get 50-50 custody, which was what she had with Mr. Miller prior to October of 2022. She is getting her supervised visitations at this time. And as I understand from both Ms. Amaskita and from my client, she is following that. We do have a hearing in the next couple weeks in front of Judge Fassett to see if there is going to be any change in circumstance regarding that visitation. But as of right now, I do not see any reason that Mr. Miller should not be getting a child support from Ms. Amaskita, as he is has sole custody of their son, and he also has a 50-50 custody with the mother of another child. And so we would ask at this time that Ms. Amaskita be paying child support for Mr. Miller having custody of their son, and that we also would ask that child support be covered in back pay going back to October when he first got custody.
All right, Ms. Amaskita, is there anything you wish to tell me?
So I was trying to get my son and I was trying to see him, but I didn't know what I had to do because I didn't have an attorney. I couldn't afford an attorney. My protected order put on me was only because of the protected order put on Mike. And when I tried to fight it, they didn't care because of the order on Mike. And that was placed on me in January. And I haven't fought mine because there's no point, because they're just going to say, I have to have it on me. I tried fighting it with proof, but Commissioner Carney didn't take my proof into consideration and just said no and put it on me. Like, I tried fighting my protection order so I could see my son, but I couldn't. And the whole I've done everything I've been told to do for the court. I took my domestic violence assessment and that was fine. Mike took his. I still haven't seen the other party's assessment. There's just a lot in the case that's going on, and I submitted all my stuff for child support, like stating like I'm struggling financially and I'm having a hard
Let me
time.
ask you a couple of questions, ma'am. So do you have other children residing with you?
3, yes.
And are
I
those
have my
your children?
sister and my baby and my 4-year-old.
Okay, and are you receiving support for them?
Yes, I get state assistance for having my sister with me.
What about for your children?
My other children, their dad isn't working. He's been looking for a job, so I've been supporting them.
All right, and where are you employed?
Walmart.
And how many hours a week are you working?
Right now, they've cut hours. So right now, less than 30.
All right, you said you make $16.64 when you work days, $19.61 when you work nights. Is that accurate?
Yes.
All right. Ms. Holder, when I look at this with the other children in her home, I think any child support puts her below the self-support minimums, doesn't it?
I believe it does, Your Honor. I would like to note that she is choosing to work part-time. If Mr. Chaddock is still in the home and he has not found a job, then he would be able to stay home with the children, which doesn't, I'm not sure why Miss Amasquita has not either been able to bump up to full-time or why she has not been able to find a second job. While I understand that there is a hardship and she is, at danger of putting her below the poverty line, Mr. Miller is also experiencing the same issue with his hours being cut, and he is also supporting and does not get child support from his other child. So I understand that the court is between a rock and a hard place here, and I do not think that the amount that the child worksheet has put on line 17 is a good indicator. I believe, quite frankly, that is too high, and I do feel for Miss Amasquita, but I do think it is appropriate considering she does have 2 people in the household who are able to work, whether they are working, part-time or unable to find a job. There are plenty of jobs that are hiring, and as to why Mr. Chaddock has not been able to find a job and Miss Amasquita is working part-time supporting 3 children is beyond me. So I do not believe that the child worksheets are accurate and asking for, over $500 is the correct amount. I do think she should be paying some child support to Mr. Miller.
Okay, well, Mr. Chaddock may or may not have legitimate reasons for not bringing any money into the household, but he's obviously not a party to this proceeding. And it sounds like both Mr. Miller and Ms. Amasquita are having problems about getting full-time hours. I can't fault either one of them for that, I don't think. So right now, I'm just going to reserve the issue of child support because I think any award at this point would put her below the self-support guidelines. If counsel there, anybody's financial situation changes, we can raise the issue again just by noting it on for hearing with whatever additional information rather than having me file a motion. But I won't order any support at this time.
Understood, Your Honor. Thank you.
Thank you.
Ms. Holder, I'm hoping you can tell me what we're reviewing.
Okay. So we submitted to the court on 8/10 my client's domestic violence evaluation and also his submission that he had completed the parenting class as per your order at the end of the trial. So I believe, does the court have that in front of it?
I do see that was through counseling and wellness.
Correct.
Okay. Yes.
Ms. Amasquita has also entered into a submission hers and Mike Chaddock's DV evaluations and proofs that they have also completed their parenting classes. With the evaluations, I'll start with my client. It was recommended that he seek treatment. He's drinking. He's currently not. He has not been for some time. And also that he be enrolled in a DV treatment program per the recommendations. He's currently in the process of coming up with the money to afford that. As of right now, he's not getting any child support and his hours been cut at his current job. On the 15th of this past month, we went to a hearing for child support, and I'm not sure which judge it was in front of. It was not Judge Evans, as was usual, but the judge reserved on the child support currently because Ms. Amosquita is not making enough money to be able to pay child support. As far as the DV evaluation on my client still adamantly disagrees with accusations from his former wife, Ms. Nicole Miller, regarding any kind of abuse. I think the DV evaluator's reliance on her allegations were weighted a little heavily in the assessment. Again, when we had the trial and Ms. Miller was given the opportunity to testify in the matter and address her opinions and why they changed about my client drastically after it responded to her initial divorce filing, she chose not to testify because she would be subject to cross-examination. As it stands, there have been no allegations of abuse or any kind of CPS reports filed since my client has taken custody of his son in October of 2023. Currently today, he has a universal trial readiness hearing at 3 o'clock for the criminal matter stemming from the October 6th incident where Mike Chaddock and Ms. Amosquita alleged that their front door was kicked in. Based on the evidence I've seen so far, I'm surprised that it's set for trial because there's no clear evidence pointing to any culprit for the broken door, and that includes statements made by Mr. Chaddock and Ms. Amosquita. Regarding Mr. Chaddock's assessment, we did have a hearing on the 31st where Mr. Chaddock asked that the domestic violence protective order be dropped, and Commissioner Carmi found that there was not a substantial change in circumstances at the time, and so the DVPO will stay in place until it terminates as an operation as a matter of law in December of this year. So that DVP is still in place, and therefore Ms. Amosquita's DVPO is also still in place because Mr. Chaddock's is still in place. Commissioner Carmi based several things on there not being a substantial change. Number one, in the recommendations made by the DV evaluator, Mr. Chaddock needed to be enrolled in domestic violence treatment. He has since done that. As of the 31st of July, he had attended 1 class. He should have had 2 to 3 classes by now. I'm not sure how many he has had. But Commissioner Carmi was also troubled for 2 other reasons. Mr. Chaddock still seems to not recognize what domestic violence is, or that he has perpetuated it in any way. And Mr. Chaddock was still adamantly asking why the DVPO was issued in the first place, and he hasn't seemed to take any kind of responsibility or accountability. And that corresponds with the DV evaluator's assessment in the first recommendation, which was that he needs to understand what domestic violence is, and he doesn't understand the underlying issues with his past treatment of his stepson. Regarding Ms. Amosquita's DV evaluation, the DV evaluator believes that she should work towards being reunited with Buddy with 50-50 custody. I don't disagree with that, and Mr. Miller does not disagree with that. However, with the DVPO still in place against Mr. Chaddock, there is still the concern that if she is elevated to 50-50 custody right now, Buddy would still be in contact with someone that there is a DVPO actively against. On a hearing on the 15th, Mr. Miller was denied any kind of child support. Like I mentioned, it's been reserved on that due to Ms. Amosquita's financial situation. In speaking with my client, she has been visiting with Buddy, but she hasn't been visiting with him as much as she possibly could. I understand that a few weeks ago she had COVID and she's still getting over that. As it stands right now, she is contacting him to see Buddy, but she tends to do it after she gets off work at 5 o'clock in the evening when he's already at work. And so the transportation arrangements just don't work out. I'm not exactly sure why she's not in contact with Mr. Miller's mother, who saw testify at trial. So I'm not sure what's going on there, why she's not able to make other arrangements. But again, as it stands right now, I think it's still appropriate to keep visitations limited and supervised until she is able to get more visitation time in, and possibly until the DVPO against Mr. Chaddock terminates in December.
I appreciate that, Ms. Holder. Thank you. So Mr. Chaddock's current order doesn't expire until December of this year.
That's correct.
And if you have it handy, do you have a specific date in December that it expires?
I'm not sure, Your Honor. The judge just said that it would terminate, or sorry, Commissioner Carmi said it would terminate as a matter of law in December. And it was for a full year.
All right. I probably can track that information down. Ms. Amosquita, any response?
Yeah, I looked over Mr. Miller's domestic DV assessment, and I was going to point out that the lady that did it said that she doesn't recommend my son being placed with him because of the past abuse with his wife, and then just some concerning things for her. And I haven't tried to like get my protection order dropped because when I was trying to fight against it in court, Commissioner Carmi didn't want to hear what I said when I provided evidence of why I shouldn't get the order. And I'm not sure when mine expires.
The evaluators said that if Mr. Miller was not seeking DV treatment, which he plans to do when he gets the money, that she would not recommend a placement with him. Not that she didn't recommend a placement with him overall. It was he needed DV assessment and treatment, which leads the court to a conundrum that if Ms. Miller or Ms. Amosquita was to get custody, then who would the child be placed with? Mike Chaddock and Ms. Amosquita, or Mr. Miller, who again has had no instances of reported DV and or CPS reports beyond what his ex-wife alleged in ever-changing declarations that she again would not sit to be cross-examined on.
Right. And Miss Amosquita, what and I just am asking for clarification. When you were, as you claim, denied the ability to provide evidence to Commissioner Carmi, was that in Mr. Chaddock's hearing to modify the DVPO?
No, that was for my hearing when I got served the protection order on me.
You mean
She
from like 6 months ago?
Yeah, she automatically approved it when I tried to argue against it.
Okay. All right. I'm going to get a date here. This case is extremely frustrating. I don't know. I think everybody knows my position that this went to trial. We should have had a guardian ad litem. There should have been some other procedures that were followed, which is no fault of any of the parties here. And it's now we're kind of working backwards from the trial, trying to figure out what needs to happen. We do have two individuals. One is the respondent's significant other. The other is the petitioner in this case and father of the child in question, both with assessments that say they need domestic violence evaluations, or domestic violence treatment. One is a 9-month term. One is a 6-month term. And that I agree with both parties. Ms. Amosquita says that he shouldn't be a placement, but Ms. Holder clarifies he shouldn't be a placement unless he's actually in DV treatment. It sounds like he's attempting to get that set up. Everybody has done a parenting plan. When I hear that other judicial officers are reviewing the case and still see concerns, and that the request to rescind the no contact order for Mr. Chaddock was denied, that obviously gives some concerns. I want to find out exactly when, let me see, when that order would end. My hope would be that all parties receive treatment moving forward, and that we can look at a more something akin to a 50-50 plan once that order is taken care of. Here is, I guess, the other. I'm not concerned necessarily about Ms. Amosquita's protection order. I think we can, because she's a direct party in this case. I think the family law case can supersede and we can deal with that. And I don't know that. Sounds like Ms. Holder isn't necessarily concerned about that if we get things worked out moving forward. But
no, Your Honor, I'm not, and Mr. Miller is not either. Again, the main concern is just bringing the child around Michael Chaddock when there's still the DVPO in place, and Mr. Chaddock he really doesn't seem to understand the repercussions of his actions and what domestic violence is, which is why treatment is necessary. but Mr. Miller is not objecting to Buddy being around Ms. Mosquito.
And Miss Mosquito, I'm assuming apart from your recent illness, that you're still taking advantages of all the visitation that you have at this point.
Yeah, and then there was all last week where Michael didn't contact me at all when I messaged him through the family app. Like I kept asking when a good time was to call, and he'd say tomorrow or the next day or the next day. And then finally I got to call him Sunday after waiting a week, trying to hear back from him of like when I can call him. Because I tried calling him one time and he didn't answer. And he was saying he was either at work or but he had a doctor's appointment. Because I was trying to schedule a time to actually see him in person.
All right.
Excuse me, can I respond to that?
Well, if your attorney's okay with it.
I'm okay with him responding to that, Your Honor.
Okay. So yeah, all during this week, the times that she was trying to set was around 5 o'clock. I was working a swing shift schedule. I had told her I would be at work, and when she had called, it was while I was at work. I can't answer my phone at work. The other times she had called, she had tried calling, like, I think it was an hour after, or she had attempted to message me. It was like an hour after she had said the time that she was going to call. And Sunday, I had worked the day shift, so I had the time, and I messaged her actually and reached out to her asking her if she would like to talk to her son. But as far as aware, weekends I work day shifts, and Monday through Wednesday I work swing shift.
Okay, well, I guess I appreciate that information. I don't know that that's an excuse. She is allowed visitation. And I
Right.
don't know, is she allowed to contact your mother instead? And is your mother, I mean, because that's who the supervisor is.
Yeah, I can set something up. I can send her a full work schedule so she knows what times to call around. That way she knows the exact times, and then that way like I can be present when I have my son, because the only issue was my son wasn't around when I'm at work. So
All right. Well, we need to make sure that those visitations are happening and that we work together on that. December 19th is the date that no contact order with Mr. Chaddock would terminate, barring any request for an extension. So I guess I'm going to ask the parties to participate in the DV treatment as recommended in their reports. Ms. Amosquita has recommended counseling, and if she is able to pursue that, I would hope that she could. And then essentially want to keep status quo and set this for December 19th, 2023 at 1 p.m. That's the day the order expires, in the hopes of entering.
All right, the next matter I have is Michael Miller and Angel Amosquita, cause 22-3-52808. And let's just double check. Ms. Amosquita is still present. We appreciate that. And I'll double check to see if Ms. Holder is on the line. Amanda Holder, counsel for Mr. Miller. And no response. And Mr. Miller, are you on the line? Michael Miller? Okay, there's no response there either. So let me just get my notes here 1 second. So Ms. Amosquita, can you hear me?
Yeah, I can.
This is, I believe this is your motion for contempt related to the $250 payment that was required to be made by the 25th of August. What I wanted to ask you is if you had provided a copy of your motion and related documents of what you're wanting, and if you had served that upon the other party, upon the other attorney, and if you had,
Yes.
if you filed a notice of declaration or declaration of service.
No, I sent it to her email because when we had our trial, she approved any documentations through email.
Okay. And then, so the second question I have is that it sounds like you served her and provided that with her. There's a second step in which you tell the court, say, hey, court, on such and such a date, I emailed these particular documents to Ms. Holder. Did you file a document or declaration that says that that happened, or that somebody?
I did not.
Okay. All right. So from my vantage point, we cannot move forward today because I don't know if service was effectuated, because I don't have that declaration that says, hey, person X, we sent this to person Y on such and such a date, and these are the documents that we sent. There needs to be that in the file. And since there's not, I'm not in a position to hear the case today. So I apologize that it took so long this morning to get to this point. But my plan is to strike the hearing today, and then you would have to renote the matter, which means put it on a docket, and then give notice to the other party that that's the date that it's set on, and then also
Sorry.
provide service, and then provide service of those documents, or submit a declaration of service to the court saying that on such and such a date, these are the documents that were served upon the other party.
So I left work early to do court because normally I'd be asleep right now because of working.
Right.
So I have to redo all the paperwork again.
Correct, in that you have to set it on a particularized docket and give notice of that new docket date, and then also make sure that you serve all the, your motion, the documents related to your motion for contempt on the other party. And if you've already done that, then you can just rehearse that you already sent those on a particular day and submit a declaration of service, or an affidavit of service, sometimes called.
Okay, so all I have to do is just re-buy the paperwork again and refill it out, and then resubmit it, re-email it, and then refill out a paper saying I emailed it.
Pretty much, yeah.
Okay. I'll try to talk to my work again too about coming in.
Okay, I appreciate that, and I apologize it took so long to get to the case today.
Okay.
All right,
Thank you.
Okay, let's return to Michael Miller and Angel Mesquita, 223-52808. Ms. Holder, I saw that she came on shortly thereafter. Ms. Holder's present. And then Ms. Mesquita, you're still with us?
Yes.
Okay, great. Just 1 moment. Bear with me just 1 moment. My notes, my search function isn't working for one reason or another, so I just need to scroll. Okay, so this is Ms. Mesquita's motion related to contempt based on an order from July 25th of this year related to payment of a certain sum. So Ms. Mesquita, I'll hear from you, and then we'll hear from Ms. Holder.
So I never received any payment after the set day, and I waited a little while and then still nothing. And so I just filed the motion for contempt.
Okay. All right, thank you. Ms. Holder?
Your Honor, I do apologize for being late. I'd like to note that, number one, my notice of withdrawal I know is not effective. There was a hiccup in my firm. Ms. Mesquita, we had sent her my notice of withdrawal effective August 20th. And so that was via email, which she accepted email service, but for some reason it never got filed with the court. So I do apologize. As such, I'm not representing Mr. Miller, and so I do not have any information as to why this was not paid.
So I looked at your withdrawal notice. I thought it said that you were withdrawing effective as of November 1.
Yes, that's correct. It was originally, I was supposed to have withdrawn, and I have an email sent to Ms. Mesquita on August 8th saying my notice of withdrawal would be effective on August 20th. However, we had a paralegal leave our firm, and for some reason that paralegal never filed the notice of withdrawal with the court. So I do apologize, and it was not until my receptionist caught it that I was able to file it currently.
Okay, so as far as the way I interpret the pleadings is that you're still attorney of record and still representing Mr. Miller as of until November 3rd of 2023. So at this point, Mr. Miller, does he have a position?
I know that Mr. Miller is extremely tight on money. He is currently going through a divorce with his wife and is strapped on cash as he only is making his mortgage payment, is not having any income coming in from his wife. And my understanding is that he is just extremely apprehensive and nervous about what's going on. There's difficulty right now putting the house on the market due to the market conditions with interest rates. And so trying to get that all sorted out. He's basically been paycheck to paycheck, and that would, in my understanding, explain why he has not been able to pay Miss Amosquita.
Okay. All right. Thank you. All right. So Ms. Amosquita, I'm going to hold off on making a finding of contempt. What I will do is reduce that $250 to a judgment and require that interest start accruing at 12%. So I'll draft a separate order and get that filed today or tomorrow. So that will happen. But I am denying the motion for contempt, but I will reduce the $250 into a judgment, and it'll accrue at 12% interest. Okay, so that'll conclude that for today. Any questions?
No,
Ms. Amosquita, did you have a question?
Yeah, what does the judgment mean?
The judgment means basically that when there's a judgment, so what I'm saying is that there was an order that said he has to pay it by such and such a date. He didn't do that. He filed the motion for contempt. I decided not to make a finding of contempt based on the representations of Ms. Holder, but reducing it to judgment allows you to pursue him legally, to put liens or to try to leverage bank accounts through legal means to get that money. So that basically a judgment means it gives you that's a tool that you can use to go after the money. Basically, you have to collect on that money through legal means.
Okay,
Okay. Alrighty. Thank you. Thank you, Ms. Holder.
thank you.
How about Miller and Amosquita, 22300528008?
I'm here.
Thank you, Miss Amosquita. Do we have Michael Miller? Michael Miller. All right. All right, we're here for a review. There was a contempt that occurred in the middle of between our trial and today's review. Miss Amosquita, can you just give me an update about where things are with your case and the protection orders and how things are progressing?
My protection order is still in place. I haven't tried to get it dropped, and Mike's drops today.
Okay.
And I've only been able to see my son once a week still because of his father's work schedule, and then his mom stopped doing visits because she's working. So I only get to see him when he's with the grandparents. And from what I've seen with visits and from his report card, his behavior is still the same when he was with me. And Mike has been going to his DV assessments, like it was said to go, like you said to go for the court order.
And is his order still in place?
It should be ending today.
So everybody but use is expires today.
Uh-huh.
Okay. And yours is, I think, is it through February?
I don't remember.
Okay. Well, I'm a little frustrated that Mr. Miller isn't here. And
I know his attorney withdrew at our contempt hearing.
I do see that he is representing himself. What I'd like to do is Are you available on the 26th at 1 p.m.? So
Of this,
next Tuesday?
hold on, let me see. Yes, that should be fine.
Let's set this over 1 week to next Tuesday. And if there's some way you can have someone let him know that he needs to be here, because there's a few things that we need to finish resolving from your case from back in August. But I don't want to make any drastic changes or ask anybody to do anything when he isn't here. So I will do that if I have to, but ideally I'd have Mr. Miller be present. So let's set this matter over 1 week to the 26th at 1:00 p.m. And if there's a way you can relay through his mother or through somebody to that he needs to be in court, that would be great.
Yeah, I could tell his grandma.
Perfect. Okay. Thank you very much for your patience. We'll set this over to the 26th at 1 p.m.
Okay, thank you.
Thank you. All right, Miller and Amaskita, 223-0052808. And I
Yeah, I'm
see,
here, Your Honor.
thank you, Mr. Miller. I appreciate that. Miss Amaskita, welcome back. All right, so we set this over 1 week because you weren't here last week, Mr. Miller, and I understand it was kind of a long out review. And I've reviewed a few things and Miss Amaskita, can you just unmute so I can make sure that you're hearing us and are there?
Yeah.
Perfect. Okay. Just know it's okay. I've had that happen before where someone stayed on mute and then they didn't hear everything I said. I did receive, let me turn around here. Last minute response from Mr. Miller, and it was looks like his grandparents. And then there was another statement, but I'm going to show you kind of what I received.
Yeah, I couldn't read it.
Yeah, I can't. It's
Oh,
so light,
yeah.
I can't read it. So I don't know whom it even is from, what it's talking about. I did read the other one. Here's where we're at. So I reviewed all your protection orders. I reviewed everything that's going on. So the protection orders that in regards to Mr. Miller and the protection order in regards to Miss Amaskita's partner are gone and over with. I didn't notice that there were any requests to re-up either of those. And then we have Miss Amaskita's protection order is up on the 6th of March, 2024. At this point, in the very brief conversation that I had with Miss Amaskita last week, she indicated that she has not taken any steps at this point to try to change that protection order. When I reviewed that protection order, it does not have a carve out or a caveat for I have to switch screens here. So just give me a second while I move things around. It doesn't have an allowance in that protection order to allow for family law to trump that order.
Okay.
So basically what that means is if I were to enter a parenting plan today, and Miss Amaskita is around the wrong people, that are like the people that are protected, there still could be a violation of the protection order because that protection order is still in place at least until March 6th.
Okay.
So, and I understand that, well, I've expressed to both of you on multiple occasions my frustration that we got to a trial setting before a lot of things happened.
Right.
So this case has kind of been drawn out a lot longer than I would otherwise hope, and I'm sure than that both of you hoped. Let me I'm pulling up that protection order just so I can look at it again while I'm,
I did want to bring one thing up when you're done.
of course. So the protection order, hold on, was entered on March 6th and it's good until March 6th, 2024.
Okay.
Here's kind of what, so there's two things that could happen. The first thing is, my thought was, because that order is what it is, and I don't have the authority in this case to change that order, that this is set for entry of a parenting plan as soon as this expires. And that's assuming that there's not a request for it to be reissued, or any issues that way. The other thing is that Miss Amaskita can always petition to have that protection order amended to allow for, because right now all it allows for is supervised visitation and electronic communication.
Right. May I say something, Your Honor?
You can.
So the whole point in the protection order isn't really revolved around Miss Amaskita. It's revolved around the person that showed signs of abuse towards my son. So the supervised visitation is really to try and protect him from Miss Amaskita's boyfriend that had left marks on his arms and repeatedly showed abuse signs. So the only reason for the supervised visitation really is just to keep him away from Chaddock, because Chaddock resides in the home. And that is something my son has been very vocal about, even in the supervised visitations. That was a part of the statement that you can't read very well. It was written in handwriting, and the copies kind of blurted out. That was kind of a statement from my mother, the one that was originally doing the supervised visitations. And in the statement, it had stated that he was very vocal about being scared to go see his mom as long as Mike was around. So my only worry is him going back and having any sort of contact with somebody that has abused him, that has showed signs that he is scared of being over there. He's gone through quite a few different routes in school for therapy. He has been doing well in school, but the one thing he's been very vocal about is going back to that house and being around just that one person. His mom is not the issue in this case at all.
Okay. Miss Amaskita, you wanted to say something as well?
Yeah, when I go see my son, it's been difficult because of Mr. Miller's mom dropping on me that she started working and I had to figure it out. So I had to go with his grandparents, and they let me see him when they have him. And I've asked for more days to visit, but he told me he can't because he's working all the time and I don't have a way to see him. I tried calling before, but I just gave up on trying to call, except when he's at the grandparents' house because of his work schedule. And then Mike's been going to the court-ordered DV classes. I don't know, has Mr. Miller been going to the court-ordered DV classes? Because I would like to know if he started those or not. Because Mike's been going for quite a few months now. And when I go see my son, he doesn't even bring up Mike's name at all. Like, when I saw him Christmas Eve, he doesn't even remember who Mike is. Like, he never mentions him when I'm around. And when I got his report card, it was kind of bad because it showed all ones, and his grandma didn't even get his report card till I showed her. And like, I've discussed school with his grandma and some other stuff that's concerning because his behavior is still, he still acts out. If he's not like taking his medicine, because when I went up there Christmas Eve, he was very acting up, like, just, you could tell he was like not on medicine. because normally when he takes his medicine, he's calm and very attentive, but he was all over the place and was just like a wild. And he doesn't listen to me. Like when I try to talk to him, like when I'm trying to have a conversation with him, he won't pay attention to me. So like I feel like I can't really try to communicate with him that well when I try to talk to him, my son. And I feel like I have no say when I'm trying to talk to him, because like the grandparents always like say stuff for him, or like I feel like I can't tell him stuff, or I'll get like judged, or like his grandparents, because of the way he was acting, told me to spank him, and I told him I'm not touching him. I don't want to spank him. I don't want to get that thrown at me and thrown under the bus, because I just feel like I can't do anything with my son, or they're just going to write statements about me saying I'm a bad person. So I just kind of feel like I'm in a bad spot right now. Whenever I try to see my son, I feel like I have to like walk on eggshells, because pretty much they can say whatever they want about me. And like, I really want to see my son, but I like have no help. Anytime they offer for me to see him on extra days, I don't have daycare. I don't have childcare. I have no family to watch my other 2 kids. And I've told that to his grandparents, and they're like, oh well. So it's been kind of difficult for me.
May I say something, Your Honor? May I respond?
Yes, let me
Okay.
respond first. I appreciate that, Ms. Amaskita, and I understand the difficulty here, and I'm going to address hopefully some of those concerns today. I don't know that we can address everything today, but I appreciate your comments. Mr. Miller, go ahead.
Okay. First off, my grandparents are, when they do have him, she is available any day to go up unless they're out of town or something. But the whole reason they took over custody was because Miss Amaskita had stated to my mother, the one doing the supervised visitation before, that the only day she had available was Friday. And it was at 4 to 5 o'clock, and she would leave by 6. She only took 2 hours to see her son. When she was up at my grandparents', they had told me a little bit about her visitations, that she was playing on her phone the whole time. They basically watched all the kids, including her own 2 that she had brought over. That the last time she had visited, she asked if she could have the Wi-Fi password so she could just play on her phone instead of having interaction with her son. And my grandfather had told her that he wanted her to interact with her son more rather than play on her phone, and instead went and laid on my grandparents' couch and took a nap. Now, I understand she's a mom. I know it gets hard, but only taking 2 hours a week to see your son when you have available 8, she has not reached out, and they have encouraged her to try and see her son more. She has made the statement that either she's busy or she's working. And she's only said the only day she can do is Friday for 1 to 2 hours. That is all she's taken upon. The last 2 months, she has not tried to call her son. And to me, it seems that she doesn't want to have it. When she does see her son, she's not having interaction with him. Instead, my grandparents basically are watching all the kids the whole time. As for the spanking comment, I don't believe that for a second. I don't believe that's a true statement. They wouldn't say something like that. So my grandparents, they took over to make sure that she could still see her son. They are retired. They do not have jobs. And if she called ahead of time and let them know, hey, I want to see him more days, she is more than welcome to take up the available 8 hours a week that she has available, but she has not taken up that opportunity.
All right. Well, I'm not concerned. I think if you were in the same situation with your work schedule, it would be hard to navigate 8 hours of visitation a week.
Right.
So I think we have to be honest and occasionally look at the situation from the perspective of the other party. Miss Amaskita is kind of in I think you're pretty well aware, as is the court, of her familial history and what she's dealing with there, not to
Yes.
mention these, what's going on in this case. So I appreciate that. And I'm sure your child wants to spend more time with mom, and I'm sure mom wants to spend more time with child.
Yes.
Being under the purview, if you were being supervised by only her family, it probably would be uncomfortable, even over an extended period of time. Even though I know, and my recollection is that you both have been a part of each other's life for a substantial period of time, and even when you were teenagers, and so I understand her. She's close with your family, but it's still, I'm sure she feels like she's under the microscope. So I'm not really concerned about the timing of all this. It's got to be hard to navigate. Miss Amiskita, I would hope, would take as much time as she could get, because we're still sort of under the same order that we've been under. So up to 8 hours a week of visitation.
I just wanted to make the court aware that she does have access to more time. Seems that, she's stating that they're denying her access. They are not denying her access. She can take any time she wants. She just needs to let them know ahead of time.
Okay. I'm looking at and I'm going to ask, so I know, Mr. Miller, you did submit your evaluation as ordered by the court, your DV evaluation. It does suggest 9 months of treatment with one class a week. Have you been following through with that?
That I did call the place. They had no available spots. I know pertaining the case with them bringing up the assault charge and the trespassing, I was found innocent on all charges. Did
those go to trial? That was something that happened
Yes.
post. Okay.
Yes, and I was found innocent on all charges. Their stories did not line up. I don't believe there's a need really for me to go. I just feel like I'm kind of being targeted. They're the opposing side. They're going to try and dig dirt on me, but I just don't see the reasoning behind it. I feel I have no restraining orders on me saying I'm abusive. I've never been arrested for abuse, nothing like that. So I don't really understand the findings of having to take 9 months of DV evaluations.
You weren't ordered. You were ordered to do the evaluation. I was just inquiring whether you followed through with the suggestion in the evaluation for treatment.
Okay, thank you, Your Honor.
And it sounds like, Miss Amiskita, you're indicating that Mr. Chaddock has followed through with, I think he was, it was a 6 months of treatment is what he was, what was suggested in his evaluation, and he has been doing that. Is that what you're?
Yeah, because we were under the assumption that everything was court ordered, so he did it to follow the order.
Okay. It was ordered, the evaluation was ordered, and to provide the results, there wasn't a direct order to follow through with the recommended treatment. Given, I think it's appropriate that he did that, and I think that's a good thing that he did that. Well, here's where we're at. So with this, the more I look at the protection order, and it sounds like potentially Mr. Miller may be agreeable to this, but Miss Amiskita, with this order in place, if I enter a parenting plan, it's really not going to do any good until March 6th. Because this specifically prohibits you from having direct contact that's not supervised with your child. So if I were to change the parenting plan at this point, it could, arguably could set you up for a violation. And I don't know if Mr. Miller is willing to, if you were to file a motion to amend the protection order that's currently in place for the next 3 months approximately, to allow for unsupervised visitation, then we could move forward in getting a kind of a more stabilized parenting plan in place. I understand that Mr. Miller still has reservations about Mr. Chaddock. And the order that at this point is that any visitation that Mr. Chaddock not be a part of that, and that would remain in place. Because that's in the parenting plan case, not in the protection order case. And would allow you to just have your child go on an outing, do what you wanted to do without Mr. Chaddock, and just have some one-on-one time with your child. But given where we're at, I'm not going to do that because I don't want to set you up for a violation in that other cause number. So I can't give legal advice. I'm suggesting that maybe you speak with Mr. Miller about what he's comfortable with until that order is gone, as far as like maybe amending it to allow for contact with the child as long as Mr. Chaddock isn't present. Otherwise, my best suggestion, given the status of this case and that all protection orders besides this final one have now lapsed, would be to set this for review on March 6, 2024 at 9 a.m. for entry of a parenting plan, because that would be the date that the protection order exhausts itself.
Can I ask something?
Mhm.
So I know like when I like tried to fight it, the judge or commissioner didn't really want to listen to me because I
Are you
didn't have
talking about the protection order?
yeah, for the protection order I had.
All right.
So I didn't think there was a reason to try to fight it because I didn't have an attorney to help me with it. And I can't afford an attorney to help me fight it. And if I was to do that, like, what if he decides to go put another protection order on me or Mike? Like, I can't stop him from doing that. And then I can't stop him from like having his family say more stuff about me. Like, I'm kind of at a like I don't really know what to do because like I feel like anything I do, even if I like fight the protection order and get like able to see my son, I feel like he'll just go around and start saying stuff again and have even more problems in the future. I just don't know what to do.
Well, I can't give legal advice. What I would suggest, however, is that you get some kind of if you're allowed to, the protection order allows you to talk to, hold on, let me just bring this up again because I don't want to misquote it, but it allows for electronic communications between the adults regarding the welfare and visitation of the child. So that says via a family app. Do you guys have Our Family Wizard, or is it Our
I
Family
still
Wizard?
have it. I
Okay.
don't know when it comes out again because I don't know when it comes out of my account for paying it.
Okay, you should be able to do the free version for at least message exchanges. The paid version has calendaring and all that other stuff, but the protection order allows electronic communication in the family app for welfare and visitation. What I'd like to see, and is an attempt at communicating to schedule sort of a regular visitation while this protection order is pending, and make and see if because I'm not going to negotiate this in open court on YouTube. But I would like to see if there can be maybe an agreement on how to move forward. My thoughts and my hope is that Mr. Miller wants you to be a part of your child's life.
I do.
But it's just a matter of how we can make that happen and alleviate the concerns he has about your current partner. And maybe showing him what your current partner is doing as part of that evaluation would be helpful to him. That he's taken that seriously and has taken steps to address those concerns. But I think what I am going to do, so Kaylee, if we could set this, and I hate that there's not a conclusion for you folks, because I think that would be really in your best interest. But I don't, as I already explained, I don't want to enter a parenting plan now that isn't going to work. So I'm going to set this to March 6th, 2024, 9:00 a.m. That's the pro se docket. So that's a docket specifically for folks that don't have attorneys.
Okay.
You can, Miss Amaskita on Mondays and Mr. Miller on Mondays at the Hall of Justice here in Cowles County on the second floor. And I think they're not starting back up until maybe the 22nd of January. I'm not entirely sure. So I think the 15th, is it 22nd?
Yes.
Thank you, Kaylee. The 22nd of January, I think, is they're starting back up from noon to 2 p.m. There are attorneys that are that help people that need information about how to do paperwork or what they can do and not do. So I encourage you to come to the Hall of Justice on a Monday and see if you can meet with one of those individuals and get maybe the legal advice I can't give you in this case, to see how you can be prepared for a plan that everyone can work with, that hopefully can get entered in March. That makes sense?
Yeah.
Okay. And if there's an agreement to amend that protection order, and you file something, on the protection order docket to do that, and if there's an agreed parenting plan that the two of you can be comfortable with, you can always enter it sooner than that. Okay. But I encourage you to reach out to the attorneys that are volunteering on our and Miss Amaskita, they can talk to you about the protection order portion as well. So it's not just a family law. They do kind of all sorts of different things. So and it's starting back up on Monday the 22nd. Okay.
Okay.
And then we'll set a review for March 6th, 9 a.m. That's going to be the pro se family law docket.
Okay.
And my hope is that we have a proposed parenting plan at that point, and both of you can file your own proposed parenting plan, and we can kind of move forward from and get some kind of consistency in visitations for this young man.
What day again?
Wednesday, March 6th, 2024, 9:00 a.m.
Okay.
And like I said, if something happens with the protection order prior to that and there's an agreement, you can always move that date up.
Okay.
Okay.
All right.
All right. Please communicate via that app to try to get some stuff set up. And Miss Amaskita, please utilize as much visitation as you can. It's important to keep that connection. That being said, I know your concerns and I know your frustrations, and I appreciate Mr. Miller's as well. So, all right.
All right. Thank you, Your Honor.
Good luck to you both. Thank you.
Next, I have Michael Miller and Angel Amaskita, 223-52808 is the cause. I'll ask if Michael Miller is on the line today. Mr. Miller?
Yes, I'm here, Your Honor.
Okay, welcome to you, sir. And then Ms. Amaskita, are you on the line today?
Yes, I'm here.
Okay, welcome to you, ma'am. All right, so as far as today, it looks like historically there was a petition for a parenting plan filed by Mr. Miller back in December of 2022. Both parties submitted proposed parenting plans. There were some concerns at that time that both parties had different ideas as far as a parenting plan, what it should look like. We were most recently here, looks like on end of December of 2023. And the parties, there was some sense that the parties were potentially able to work out an agreement for a parenting plan. And I looked in the file and I didn't see any proposed orders. So I'm making an assumption, you can correct me if I'm wrong, that there's not an agreement as to the parenting plan. Is that so? Mr. Miller, I'll hear from you and then I'll hear from you, Ms. Amaskita.
Okay. So in my parenting plan, I was requesting that there be supervised visitations as there have been, due to having to file restraining orders against, at first it was her boyfriend, the person that was living with her at the time, due to child abuse and leaving bruises on my son's arm. And the second one I had to do because she had taken him back over to the home where Michael Chaddock resides as well. So my concern is that his safety is a jeopardy just due to child abuse, neglect, and I ended up having to take him full custody and file basically emergency custody for him in order to keep him away from that household where he showed signs of being abused. He was doing not so well in school due to he was showing a lot of the same behaviors that he was seeing within the home. A lot of those behaviors pertain to biting, scratching, spitting on people, as Michael Chaddock had stated before in the cases pertaining to the restraining order, that he had spit on my son's mom and he was hitting people, such as another behavior that he was showing and seeing in the home where he had claimed that Michael Chaddock had hit his mom. So I'm
Can I ask you a question, Mr. Miller?
yeah.
So
Yes, Your Honor.
if I understand correctly, is that the parties have not agreed on a parenting plan that both feel comfortable with. Is that accurate?
I believe so. As of right now, it's supervised visitation unless Ms. Samasquita disagrees with that.
Okay. So Ms. Amasquita, what's your viewpoint as far as an agreed parenting plan between the parties? Have the parties come to an agreement or no?
No, there was no agreement. We were supposed to have it
Okay.
filled out today, but I was gonna bring up a couple concerning things that might factor to the parenting plan.
Okay, so let me ask the parties. There was a petition for a parenting plan filed back in December of 2022. Then I see in June of 2023, there was an order by Judge Fassett. It was an interim ruling related to both parties attending a class, Love and Logic or Children in Between, communication through Our Family Wizard. Both parties get a DV evaluation, that Ms. Amasquita would have supervised visits with the children by the paternal grandmother, and that would be up to 8 hours of visitation a week, time and place agreed upon the parties. And that Mr. Chaddock would not be part of that visitation. And so is that what the parties have been working under as far as a parenting plan arrangement?
Yes,
Yeah.
yes, Your Honor.
Okay,
Everything that we needed to do is have been done already.
okay. All right, so you've done all of those things. All right, so, okay, let me just,
But I was gonna bring up just some things that were happening that were an issue for me.
yeah, so let me, before you get there, Ms. Amasquita, I appreciate your wanting to share that. The procedure, I just want to make clear where we're at, is that there's a petition to have a parenting plan put in place. There's some proposed orders that have been submitted by the parties, and there's been declarations related to that, and some of these declarations are older. They've happened months ago. What the each party's perspective was. We have a guardian ad litem. No, pardon, we don't. And then some proposed. Give me 1 second. Sorry. Okay, so I think, okay, so at this last hearing we had in the end of December. Okay, my apologies. The parties, just so I'm clear again, the parties are here today for the court to make a decision about a parenting plan. Is that correct?
Yes. Yes.
Okay, thank you, Ms. Amasquita. Mr. Miller?
Yes.
Okay, well, I'll let you know is that when I reviewed the file, the last thing I looked at was the December 26th hearing that we had. So I looked at the court's minutes from that. And there are some questions related to the protection order and the like. And then it said the court would like to see the parties make an attempt to come up with an agreement related to the parenting plan. And if there's agreement, then the parties could have it presented to the court. So I'll be honest with you. I didn't come into today's hearing thinking we were going to be talking about a full-blown parenting plan. And I apologize for that. And maybe I should have known that, but that wasn't clear to me. And I apologize that you took time out of your schedule today. I'm really not in a position because I don't have all that information that you both submitted fresh in my mind, the different declarations and the like. So what I'm proposing is that we set this matter over so that I can have that fresh in my mind and each party's respective positions. And what I show is that Mr. Miller submitted a proposed parenting plan. I think it was maybe I have noted in my notes December 8th, but there may be a earlier one. No, December 22nd was the one that Mr. Miller filed. And then I believe Ms. Mesquita filed her proposed. I got it reversed. Mr. Miller submitted his December 8th, 2022. Ms. Mesquita filed her proposed on December of 2022, of December 22nd. So that's a lot of time, especially in the life of a small person, to have proposed orders. So I think we need to kind of take a fresh look at things as far as updated proposed parenting plans. If the parties have, you may feel like the proposed orders that you submitted previously are still effective and relevant. And if they are, then you can tell me that. If they're not, then I would expect that you would submit new proposed or revised proposed parenting plans and then submit declarations to support the same. I'm looking at some different statements and documents that the parties have filed over a period of months, and it's somewhat difficult, it's somewhat disjointed in that there's a lot of documents and there's a lot of months to cover. Some of the information is dated. So this is my suggestion to the parties is that the parties would each submit proposed parenting plans. If it's the same as the one before, you can say that. If it's different, then you'd submit the proposed parenting plans and then submit a declaration or of what you feel things should be. And that would give the court some clear guidance that's current and related to the situation of the child. And then we'd come back in roughly 2 or 3 weeks to address the issues. I'll hear from Mr. Miller as the petitioner first and what you think about that plan.
Okay. Yeah, I'm okay with that, Your Honor.
Okay. Ms. Amasquita, what's your input?
I'm okay with that, but would I be able to say a couple of issues I've been having since the last hearing that we had with I forgot her name, Miss Fassett.
Judge Fassett?
Yeah.
As far as that's obviously important in your mind. It sounds like Ms. Amasquita, there's no motion pending before the court other than this issue of the parenting plan, which I wasn't, I'm not prepared for that today because I was thinking we were doing something else. So if you have issues related to Judge Fassett's order, that order is still in effect. That order still controls. If either party feels that order has not been followed, then you can file a motion for contempt in that you're alleging that order has not been followed. So while there may be concerns related to that, I'm not inclined to hear concerns about that particular issue without a motion pending before the court. There has to be kind of that a filing of a document with notice to the other side so they can be aware of what's happening and they can respond. So Ms. Amasquita, I appreciate you raising those potential concerns. I haven't heard them, but I think it's more properly set at a hearing where all parties have been given notice of what the topic is and that other side can respond, and then you can reply to their response, and then the court can be aware of things. So I'll politely decline that invitation to address that issue.
Okay.
As far as a date to come back, March, we could set it over 2 weeks to the 20th if the parties need a little more time to
get that in. It could be the 27th. Mr. Miller, what is your preference?
I'm okay with that, Your Honor.
Okay, Ms. Amaskita?
Let me look, hold on. I gotta look at my schedule.
Okay.
The 27th?
Or the 20th?
The 20th works for me.
Okay, it sounds like Mr. Miller, that works for you also. Okay, so we'll set the matter over to March 20th. This is what I'm anticipating, that the parties will file some type of declaration, each of you laying out what you feel that the parenting plan should be and why that's in the best interest of the children or child. And that if there's a different proposed parenting plan, you would say so and you would submit that. And if it's the same proposed parenting plan, you would say that and make reference to that. You would each then file your documents with the court and serve a copy on the other party so they know what you're having to say. And then both parties would be free to read what the other had said and then submit a reply, a declaration limited to 2 pages. So any questions, Mr. Miller?
No, I'm okay, Your Honor.
Okay. Ms. Amaskita, any questions?
So if I was to file a motion for contempt, would it be a different court date than the one on the 20th? Or would I just wait for the 20th?
You could, if you feel like there's a motion contempt, you could note that up for a particular date, and you can check with the clerk's office for an appropriate date and time.
Okay.
So let's set this matter over to March 27th, and we'll hear that the respective positions of the party related to the parenting plan at that date and time. And then Ms. Amaskita, if you want to file, then that's probably gives everybody enough time to respond to that, and that could potentially be heard on that same date for any motions for contempt, and vice versa for Mr. Miller.
Okay.
All right, with that, we will conclude the hearing. Thank you both. We'll see you on the 27th of March at 9 a.m.
Thank you.
Thank you, Your Honor.
Next, I have Michael Miller and Angel Amaskita, 223-52808 is the cause number. I'll ask if Mr. Miller is on the line.
Yes, I'm here, Your Honor.
Okay, welcome to you. And then I'll ask if Ms. Amaskita is on the line.
Yes, I'm here.
Okay, welcome to you also, ma'am. We're on today for Ms. Amaskita's motion for contempt related to communication and not using the parenting app. And it looks like there was service of that motion on Mr. Miller back on March 11th. And we were here previously, and I'm not sure, Mr. Miller, have you filed anything with the court related to a response to that motion for contempt?
For that, I believe that issue was the last judge we had, I can't remember her name. She had said the app was unreliable. I know it was working for me at first, but then it started cutting out. It kept kicking me off. I wasn't able to get on it. So I've been having a lot of technical difficulties using the app. And I know she's talked to my grandparents. My grandparents have told me that they have talked to her and told her that the app has not been working for me. And I have not been able to get on the app.
So did you file anything since March 12th when that motion was served upon you?
I don't believe I have.
Okay. So at this point, Ms. Amaskita's allegations stand unrebutted. So I'm in a position to grant her motion for contempt. And I'm not sure why you didn't file anything.
Oh.
Okay. So at this point, Mr. Miller has indicated that he's had some technical difficulties related to the parenting app. There's an order from June of 2023 that's the app that's to be used by the parties. Ms. Amaskita alleges that Mr. Miller is not using the communication app. He doesn't open up the messages, and she showed documentary proof that the messages remain unopened and unread, and that there's not the communication regarding their mutual son. So that's kind of the varying viewpoints on the issue. Anything else to add to that, Ms. Amaskita?
I've talked to his grandparents about calling me too, like using his phone to call and have our son talk to me. He hasn't even done that. The only time I get phone calls are whenever our son's at the grandparents' house. Like we communicate sometimes about me calling them, or they randomly have him call me, but I never get a phone call when he's with his father. I get no communication at all, even like through texting or anything.
Okay. And I'll give you the final word on that issue, Mr. Miller. Anything else you'd like to add?
Yes. As for text messages and phone calls, I know I've always been okay with her communicating me through that. And I know phone calls, she's aware that she can always call to talk to her son. I'm not trying to withhold him or anything or say she can't talk to him. I just know that usually her supervised visitations are up with my grandparents. So at the time, usually it's maybe I'm working at the time, and that is usually the easiest way for her to communicate with them, especially on the weekends.
Okay. All right. Thank you. All right. So in any motion for contempt, the court looks at the underlying court order. This is the court order that relates to the proposition was filed on June 9th of 2023. It's entitled Court's Interim Ruling. It indicates in paragraph 2, communication between the parties is authorized and shall be done through our Family Wizard parenting app. This shall be the method of communication for the parties, regardless of the status of the protection orders. So that's the controlling provision related to the motion for contempt. Mr. Miller indicates he has technical problems. The order's been in place for roughly 9 months, 9 months plus. And if there's a concern related to a court order and there's an inability to follow through or comply with that, the expectation is the court would be made aware of that. And if there's difficulties, then it could be adjusted. Here, there's not an explanation related to efforts to control or to fix any potential technical issues related to our Family Wizard. So I'm going to grant the motion for contempt and impose a $100 civil sanction against Mr. Miller that he'll need to pay. And then the parties are also reminded that 2003 June order still controls regarding the communication. So that our Family Wizard app has to be through which the communication occurs. That's the baseline. If parties want to use a telephone to make phone calls or video conferencing, you can do that. That's basically, that's something you can do. But if there's not agreement with altering or deviating from the court order, then you have to go with the court order. But if there's agreement, certainly you can deviate from that. So I'm going to take just a moment to give myself a notation here so I can prepare that order. I'll get that order drafted and the parties can take a look at that. It should be filed no later than on Friday afternoon. The next issue is that I had asked the parties to submit additional information through pleadings related to the parenting plan, because at this point there is no parenting plan. There's kind of this interim ruling from June that indicates Mr. Miller is the primary parent related and having non-emergent health care and the like until there's a parenting plan issued. So we don't have one at this point. And so I asked the parties to submit additional information, which you both did, and I'm grateful for that. There's enough information that's out there that's I think that what I want to have additional information through the appointment of a family court investigator. Here the indication is Ms. Mesquita wants a 50-50 type plan. There's concerns related to foreclosure where Mr. Miller's living. There's concerns for domestic violence in both homes. There's concerns of videos and violence and video games and the like. So I think it's appropriate at this point related to, and also there's the concerns of Mr. Chaddock and Ms. Mesquita's home. So, and I recognize that it looks like he completed the DV course, the 24 week course. I recognize that also. So what I'm going to do, I'm going to appoint the family court investigator, Ms. Schaefer, to speak to the parties and investigate a little bit further to gather more information so the court has a more clear picture in addition to the information that you all have submitted here just recently, which I'm appreciative of. So in the interim, with that order, I'll appoint her as the family court investigator. She'll be contacting each of you. As far as contact information, I believe the addresses and phone numbers were filed in your most recent pleadings. So Ms. Mesquita, you've got a the Mill Street address and a phone number ending in 6066.
Yeah, that's correct.
Okay, and then,
Oh, 6016.
oh, yeah, that's right, 6016. And then with
Yeah.
Mr. Miller, I've got an Alpha Drive address and a 2333 phone number.
Yes, that is correct, Your Honor.
So that'll be the information that Ms. Schaefer uses to contact you. So she's going to do some investigation, and then she'll file her report, and that'll be noted up on a docket so we can address the parenting plan. I think there needs to be a parenting plan put in place, at least on a temporary basis, so there's greater clarity, and so the best interest of the child can be preserved more precisely. Again, I'm just going to take a minute to write down a note so I can prepare that order. And also, until that next hearing, I'm ordering that neither party utilize corporal punishment on the child. That means no spanking, no slapping of hands. There's just to be no physical punishment of the child. Certainly, there can be timeout and other means, but no forms of corporal punishment. Any questions from the parties on that point?
No, Your Honor.
Ms. Almaski?
Yes, I had a question. So my protection order is gone. What about my supervised visitations? Like, what goes on with that? Because that was with the protection order.
That's part of the issue. That's part of the issue is that right now, the only kind of parenting plan guidance that's at the end, at least that I can find, and you can point me to something else if I'm missing it, is from June of 2023, where it's noted the court's interim ruling related to communication, getting a domestic violence evaluation, indicating that Ms. Almasquitas to have supervised visitation with the child to be supervised by the paternal grandmother, assuming she's willing to do that. And you're available to have up to 8 hours of visitation a week with the time and place to be agreed. And the parties can choose to break that up into multiple visits. And the visitation shall happen only with Ms. Almasquita, and Mr. Chaddock shall not be a part of the visitation at any time. So I would just point to the parties to that June 9th, 2023 interim order as kind of the guiding document at this point until we get more information from the family court investigator and court issues a temporary parenting plan.
Okay.
Any other questions from you, Mr. Miller?
No, Your Honor. Thank you.
Okay, Ms. Almasquita, any questions from you?
No.
All right, so I'll get those orders out. And again, the family court investigator, please promptly return her communications, and then we'll be back on that as it's docketed once she has her report completed.
Okay, thank you.
All right, that'll conclude the hearing. Thank you.
Your Honor, may I say something?
Tell me your name.
My name's George Miller. I'm the grandpa of Buddy. I'm the one that filed with CPS and started all this. As far as visitation,
What are the names of the parents involved?
My name's George Miller.
What are the names of the parents involved?
Mike Miller and Angel. I can't pronounce her last name.
So we just had the hearing. You probably heard what I said, and so you're not a party. So we'll rely upon what I said in that case. So you can address any concerns at a later time. We're done with the case for today. Thank you.
Michael Miller and Angel Amezquita, 223-52808 is the cause number. Michael Miller, are you on the line today?
Yes, I'm here, Your Honor.
Okay, welcome, Mr. Miller. And then I'll ask if Angel Amezquita, if you're on the line.
Yeah, I'm here.
Okay. All right. Welcome to both. This is a motion brought by Mr. Miller for a show cause hearing. Let me just double check first. Mr. Miller, I didn't show a proof of service that you'd filed a motion. You'd served Ms. Amezquita with the motion and declaration. However, Ms. Amezquita filed a response. And so I'm not sure where we stand with service.
I have served her. My mother's the one that served her. We had filled out the papers and turned it into the courthouse. I believe it was Friday.
Okay. All right. Let me check with Ms. Amezquita. Ms. Amezquita, did you receive a copy of the documents related to Mr. Miller's motion for contempt?
Yeah, I did.
Okay. So two ways to approach this. One, we can proceed today with the assumption that you were properly served with all the documents. Otherwise, we'd need to make sure that the service was effectuated, and I don't have that information today, so we'd have to set the matter over probably 2-3 weeks. So preference on your end, Ms. Amasquita?
I'm fine to go ahead and continue for today.
Okay. All right. We'll indicate that the service was proper. I'll hear from you, Mr. Miller, related to the encounter at Winco and Mr. Chaddock. So I did review that on April 11th was the indication. I did review Ms. Amasquita's response related to the pictures and the receipts. Go ahead, Mr. Miller.
Right. So on April 11th, around 7 p.m., me, my significant other, and her child, along with my son, Buddy, we had gone grocery shopping, went into the store, and proceeding into the entrance, we had noticed that Michael Chaddock was walking out to the exit, and nothing really happened. We walked by, but later proceeded to get towards the back of the store on the opposite end where Mr. Chaddock says he had gone back into the store to purchase milk. And Mr. Chaddock had proceeded to walk up to not me, but my son when I had my back turned. I was looking at the cheese, but he had proceeded to walk over and try to interact with my son. And from my understanding is the temporary parenting plan we're basing this off of, that he's not supposed to have any sort of involvement with the visitation. And I had asked that he leave me and my family alone 3 times, where he refused, and continuing to try to walk away, he proceeded to almost stalk us around the store. And I had called the police in that matter and asked what I should do due to that interaction, because I have this case in family court where he's not supposed to have involvement with my son. And as noted too, my son, at the time that Michael Chaddock had came up and proceeded to try and talk to him, he was scared and hiding behind my back. I know he still asks me, even now, every time we go to the store, he's scared that he's going to run into him, and, stated that he doesn't want to go to the store because Chaddock will be there. And I know it has caused a lot of traumatic memories for my son, because now he brings up a lot of issues, like when he was 5, about all the incidents that occurred over at that house involving Chaddock.
How old is your son now? Is he 6?
He is 7.
He's 7. Okay. Okay, let me ask you a question, Mr. Miller, regarding the order from June of 2023. It restricts Mr. Michael Chaddock from, it says he shall not be part of any visitation with the mother. So here you're asking for a motion for contempt related to not following that order. So it doesn't appear to be a violation of the particular order. It appears to be a very disconcerting interaction for yourself and for your son. So do you have any input on that related to the kind of the basis of any contempt order? Any contempt finding is a court order, and the court order says can't have any participation in any visitation with the mother. There's no, in other words, there's no strict prohibition from contact from him to you or to the child.
Okay. I know I had talked to the police. They had told me to fill out an anti-harassment protection order. So I took the police officer's advice and did that. The order was denied due to just the history of the case and having a previous protection order already. She didn't feel it was necessary. That she said it was an issue that needed resolved in family court.
Okay, so you filed the anti-harassment order. Did you get a temporary order and then there was a full hearing on it and it was denied?
Yes.
Okay, so there's the temporary and then the full. All right. And then the court indicated that did the court give you a written ruling as far as the denial?
As far as I know, it said that there wasn't enough evidence of harassment.
Okay.
or domestic violence. I kind of based it off of, the history of the case, and the the main reason I wanted it was to protect my son, just keep him safe and prevent any future occurrences from happening, and prevent this future issue from happening of running into him and having this mishap happen again.
Okay. And I'm just looking. When was that hearing? How recently was that hearing in which the full order was denied?
It was this Monday.
Oh, this past Monday. Okay.
Yes.
Madam Clerk, are you seeing, I pulled up, maybe you can tell me, do you have a cause number by chance, Mr. Miller?
I don't on me. Sorry, Your Honor.
Do you know if it was in the morning or the afternoon when the hearing was held on Monday?
It was 9 a.m.
In the morning, okay. Ready? I'm taking a moment just to pull up that case that was heard on Monday. I just want to take a look at what the judge had done there. Okay. Thanks, Mr. Miller. I just reviewed that and it comports. I reviewed the notes and it comports with what you had indicated.
Okay.
Right. Thank you. Anything else you want me to consider, Mr. Miller?
As far as I know from the documents they had turned in as well, concerning the protection order that I tried to get, and what Miss Amasquita had indicated was that he was in communication that he had tried to come back in the store, and as far as I know, he knew that my son was there, and he chose to try to interact with him, even knowing the history of everything that we've been going through in court.
Okay. All right. Thank you, Mr. Miller. Ms. Amasquita, anything else you want to share?
I just wanted to say that Mr. Chaddock went to the store to buy stuff to unclog our drain, and then he forgot milk, and so he messaged me if I needed anything else, which I showed. And me and him did not know that Mr. Miller and my son would be at Winco. So when he walked back in, he said, like, when he got home, he told me Mr. Miller was the one harassing him and making a scene and yelling at him. And I told him to just document it. And like, Mr. Chaddock's concerned about future encounters if Mr. Miller is going to keep harassing him or making a scene, because he doesn't even want to go out in public sometimes because of wanting to like run into them and having this happen again. And I understand, like, it's a public place. It's just like there's no way to like prove either or side.
Okay. All right. Thank you, Ms. Amasquita. Okay. So here, Mr. Miller brings a motion for a show cause on for a finding of contempt related to the June 8th, 2023 order, which basically says that Mr. Michael Chaddock shall be played no part of any visitation time with the mother. That's the order. The order doesn't specify any no contact provisions or anti-harassment provisions. So I'm going to deny the contempt. The order prohibits him from being part of the visitation. This wasn't a visitation at the Winco store. So, word to the wise, I don't think at this point I'm going to order anything other than just telling Mr. Chaddock that he really has no business having any interactions with the Millers, and the Millers really have no any good reason to interact with Mr. Chaddock. The parties be wise to stay away from each other.
So I'll deny the motion for contempt and just encourage the parties just to do your best to stay away from each other. That'll conclude the hearing. I'll draft an order to that effect that denies the motion for contempt. Any questions from the parties?
No,
Your Honor, thank you.
All right. Thanks for your time. That'll conclude the hearing for today.
thank you.
Next, I have Michael Miller and Angel Amasquita, 223-528-08. I'll ask if Mr. Miller is present. Mr. Miller?
Yes, I'm here, Your Honor.
Okay, welcome to you, Mr. Miller. And then Angel Amasquita, are you on the line?
Yes, I'm here.
Okay, very good. And I see that Ms. Schaefer, the family court investigator, is present. Can you hear me okay, Ms. Schaefer?
Yes, Your Honor.
All right, very good. So we're here for a review of the family court investigator report. It was filed on June 7th, just confirming that all parties received a copy of that report. Mr. Miller, did you get a copy?
Yes, I got a copy, Your Honor.
All right, good. And Ms. Almasquita, did you get a copy?
Yes, I got a copy.
All right, very good. And then you noted, it looks like Ms. Almasquita, you noted this up for a hearing based on that report. Is that correct?
Yes.
Did you file any type of motion or you're requesting a particular relief or outcome based on that?
No, I don't think so, because I just filed it for the review for that. I didn't really
Okay.
know what to file it under.
Okay, so there's some recommendations that were made that Ms. Schaefer had made. She recommended that mother's visits be unsupervised, and Ms. Schaefer, you can jump in and correct me if I'm in error. That they would be unsupervised on the weekdays. It'd be between 2 to 3 hours, and on the weekend it'd be up to 6 hours. And it's okay to bring the younger child for the visit with the older child. And any visits outside of Kelso or Longview would be approved by the father and require 24 hours notice. And that Mr. Chaddock would not be present or in the vicinity of the visit under any circumstances. And that there'd be joint decision-making for school and health issues, and that no significant other or romantic interest would be introduced to the children until after 6 months of consecutive dating, and that there'd be no disparagement or negative speaking of either party or by significant others of the other party in front of the child. So that's the recommendation. Ms. Schaefer, anything to add to that?
Yes, Your Honor, if we could just clarify that the unsupervised visits are community-based only and are not to take place in the family home.
Thank you. All right, so that's the recommendation. So Ms. Amasquita, so with your review, generally, when an investigator or a guardian ad litem issues a report, sometimes the parties both agree with that. Sometimes they disagree with parts or portions, or sometimes there's disagreement by both parties. Are you in agreement with the family court investigators' recommendations or in disagreement?
Yeah, I agree with her for the unsupervised visits.
Okay. And then there are some other items that I listed, conditions such as Mr. Chaddock not being
Yeah, that's
present or
fine.
in the vicinity. Okay. And you're okay with joint decision-making for school
Yes.
and non-emergent healthcare?
Yes.
And you're comfortable with the no introduction of romantic interests or significant others until 6 months
Yes.
of dating? Okay. And no disparagement of either party by yourselves or any significant others?
Yeah, I agree with that.
Okay. And then the weekday visits up to 2 to 3 hours unsupervised in the community, but definitely not in the home. You're comfortable with that?
Yeah, I'm comfortable with that.
And then the weekends up to 6 hours with those same conditions of being unsupervised, community-based and not in the home.
Yes.
Okay. And you're comfortable with the requirement or the condition if the visit occurs outside of Kelso Longview, that has to be approved by the father and has to be given with 24 hours notice.
Yeah, that's fine.
Mr. Miller, what's your take on the family court investigators' recommendations?
I agree with it. I agree with the majority of it, the unsupervised visitation part. I personally have a little bit of trust issues with it, but I would have liked to get to this point. So I'm gonna agree with her on the report.
Okay. So the next step, I guess, to ask both parties, with the investigator having made those recommendations, that those recommendations then can be transferred into a temporary parenting plan that the court would then sign, and then that would be binding upon the parties. And then you'd have to follow that until there was, unless changed in the future by the court. Do you have any thoughts on that, Ms. Amasquita?
Yeah, that's fine. I don't know how it would like look per se.
When you say you wouldn't know what it looks like.
I know, would it be like daily certain times of the day, or would it be just,
Yeah, it's a good question as far as your visits.
yeah.
Yeah, it's not specified, and that may be something that needs to be worked out between the parties. So yeah, so at that point, it's kind of open-ended. There's not it doesn't say every Tuesday and Thursday from 4 to 6 or 4 to 7. It doesn't say weekend from noon to 6. It doesn't say any of that. Sometimes parties are able to work with that openness. Other times parties are not able to do that, and they need more strict guidelines. So I don't want to pressure anybody into doing anything. If you agree on certain things, great. And it may be premature because you haven't even talked about it. It sounds like in principle, you're both in agreement with the recommendations by the court investigator. But there may be some more details that need to be fleshed out between the parties. Mr. Miller, what do you have? So I guess what I'm saying is that I don't necessarily want to take the time right now to kind of work out those details unless you already have those details in mind and there can be agreement on it. And again, I don't want to force anybody into agreeing to anything. It may be that the parties, we take some time, or you take some time to talk about, the specific times and dates for the visits. Or if you feel comfortable with kind of the more vague terms, that would be okay too. And then come back and you can tell me. So I'm fine if we want to proceed today. I'm fine if we want to take a little time to work out things. We'll hear from Mr. Miller and then Ms. Almasquita.
I think it'd probably be a better idea to just take some time to kind of work out the details, if we could, Your Honor.
Okay, Ms. Almasquita?
Yeah, that's fine, because I just have to figure out about my work schedule.
Okay. Ms. Schaefer, any input at this point?
I really just left it vague because of that. Ms. Amskita's work schedule can change from time to time, and I didn't want to lock her into something that she couldn't commit to.
Makes sense. Okay.
Your Honor, this is Beth Fellows. I'm the one that's doing the supervised visitation.
Okay.
I had a quick suggestion or thought is she has 2 hours on Thursdays that are professionally supervised. Maybe those could go unsupervised with those restrictions in place until maybe the next couple of weeks when you come back into court.
And is that 2 hours of supervised visitation on Thursday, is that in a court order?
I believe the supervised visitation is right now it's been scheduled as 4:30 to 6:30.
Okay.
Weekly on Thursdays.
All right, so that sounds like an option the parties can consider and take into account and make some decisions. Thank you, Ms. Fellows, for sharing that. I guess what I'd like to do is give the parties rough 2 weeks. We could come back in 2 weeks. You all could exchange information. I do want to see, if you don't come to an agreement, I do want to see your proposals in writing if they differ from each other. So that means you'd have to submit some type of declaration or a proposed parenting plan of what you think the contour should be and submit it to the court and serve a copy to the other party. That way I'll have a clear idea of what any disagreements are and what decisions need to be made.
Okay.
So we can plan on coming back on August 21st. The parties, if you come to an agreement, then you come back on the 21st and tell me what that agreement is. If you don't come to an agreement, then you'd both need to write up what your respective thoughts are, what the way you think things should be, submit it to the court and file a copy to the other party.
Are you comfortable with that, Mr. Miller?
Yeah, I am, Your Honor.
Ms. Almasquita?
Yeah, I'm comfortable with that. And I do like what Beth did recommend too for now.
Okay. All right, the parties can talk about that. Ms. Schaefer, do you want to be included in those submissions by Mr. Miller and Ms. Almasquita?
If it helps assist the two of them to come to times that work for both people, I'd be happy to assist in that.
Okay. All right, so there's an offer of help there that Ms. Schaefer is willing to assist with that also. So we'll plan on coming back on the 21st of August. If you're in agreement with specific timeframes for visits or what have you, then let me know that. If you can't come to an agreement, then you'll need to file by latest next week. File what your disagreements are and what your proposed parenting plan would look like in the times, and then we'll come back here on the 21st and make a decision on that.
Your Honor, I had a quick question also.
Go ahead.
Is there any way we could get off of the family wizard communication if she's comfortable with that? I know I've had technical difficulties with it sometimes where messages aren't popping up for me and I end up seeing them like a way later time.
If I'm assuming that our Family Wizard app is required by a court order, is that correct?
Yes, the current one.
So if the parties feel that their need do you want to have a change with that? You can submit an agreed order, or if you want to change something and Ms. Almasquita doesn't, then you could file your motion and she can reply, and then the court would make a decision on it.
Okay, thank you, Your Honor.
Okay. Ms. Almasquita, any final questions?
No, I don't think so. Not at the moment.
Okay, we'll see everybody on the 21st. You can either tell me if you're in agreement, and if not, you will both have filed and shared with each other your respective plans for the visits. We'll see you on the 21st.
Okay, thank you.
Thank you, Your Honor.
Thank
All
you,
right, thanks.
Hannah.
Next, I have Michael Miller and Angel Mesquita. 22-300-52808 is the cause number. Ms. Schaefer is the family court investigator. She's on the line. Angel Mesquita, I see that you're on the line. Can you hear me?
Yeah, I can hear you.
Okay, welcome to you. And then Michael Miller, are you on the line today?
I didn't see him in here.
I haven't seen him yet either, Your Honor.
Okay, I'm not seeing him. Michael Miller, if you're on the line, please make sure you're unmuted and state your name. It looks like he's not in the courtroom. He's not coming forward. If he has come forward, and it looks like he's not on the Zoom call today. So we're here today. It looks like there were some recommendations given by the family court investigator on the 7th of August. Largely, it sounds like the parties agreed with that, but they wanted to kind of work out some finer details. And if they disagreed, then they would file a proposed parenting plan. According to my court or review of the court file, nobody's filed any updated parenting plans. So as a result, I'm assuming that the recommendations made by the Ms. Schaefer carry sway. So I'll hear from Ms. Almasquita.
So I did talk to him and I did let him know that with my work schedule, I can do visits the Thursdays that we've been normally doing them from 4:30 to 6:30, and Friday I can do them that day. And then some Saturdays I'm available for longer visits as well.
Okay, and that would be this up to 6 hours on Saturday, and then the
Yes.
3 hours on the weekday.
Yeah, and then I told him on Saturdays if our child wants to go back home because of how long the visit is, if he just like gets tired, I would bring him home.
Okay, all right. Ms. Schaefer, have you had any contact with Mr. Miller?
No, Your Honor, I haven't. I think we were just deciding what days as Ms. Amsakita's schedule kind of fluctuates, and there just wasn't clarity in my recommendations for that.
Okay, so Ms. Almasquita, it sounds like Thursday, Fridays during the week, those are the best days.
Yes.
Okay. So what we have, the recommendation is that the custodial parent would be Mr. Miller, with Ms. Almasquita's visitations occurring unsupervised in the community on Thursdays and Fridays for up to 2 to 3 hours, and on Saturday up to 6 hours.
and it's okay to bring the youngest child to the visit. And if there are any visits outside of the Kelso Longview area, there needs to be approval from Mr. Miller 24 hours prior in advance. Mr. Chaddock would not be present or in the vicinity of the visit under any circumstances. And then joint decision-making on school and health, non-emergent health issues, and that no significant other or romantic interest introduction to the children until there's been 6 months of consecutive dating, and that both parties are prohibited from disparaging the other party or their significant other. So those are the recommendations. So any comments on those, Ms. Samasquita?
Just with the medical thing, I had to re-add myself to my children's medical because I was removed by Mr. Miller's grandma. So I had to jump through hoops to be re-added back to all my children's medical stuff at the doctor's office.
Okay, so you're back on there.
Yes, and I made a note that only me and Dad should be involved with medical stuff.
Okay. And you made that note with the provider?
Yes.
Okay. All right. So let me just go back here a little bit. Ms. Schaefer, you filed your report back early part of June, was it not?
I believe so, yes.
Okay. So we need to memorialize that ruling that the court is adopting the family court investigator's recommendations. And generally that's done by one of the parties, and then it's drafted and then sent to the other party, and then we copy sent to the court. And then we have set a date for everybody to have reviewed it and then sign off on it. Ms. Almasquita, tell me about your comfort level in preparing such an order.
I can try. Would it just be like filling out a parenting plan with what we talked about?
Yes.
Okay.
So let's do that then. Let's look at a date. Today's the 21st. Let's plan on coming back on September 4th at 9 o'clock in the morning. So Ms. Almasquita, you'll prepare that parenting plan order and based on the family court investigator's recommendations, and supply that to Mr. Miller, and then supply a copy to the court also. And send
Okay, and it,
and send
sorry.
one to Ms. Schaefer also.
Okay.
Ms. Schaefer, do you have any comment?
No, Your Honor.
Okay. All right, so we'll look forward to seeing that that proposed order, and we'll be back here on the 4th at 9 o'clock in the morning.
Okay, thank you.
All right, thank you.
Thank you.
Angel Almasquita, are you on the line? Angel Almasquita?
Yeah, I'm here.
Okay. Ms. Almasquita, I've been calling your case a number of times and you weren't present. Were you elsewhere? Ms. Almasquita?
My phone's having some internet problems right now. It's keep cutting in and out.
Okay. All right, I'll ask if Michael Miller, if you're still on the line.
Yeah, I'm here, Your Honor.
All right, thank you. All right, so at our last hearing, let me just pull up a couple of documents just a moment. At our last hearing, there were some recommendations made from the family court investigator, Ms. Schaefer. The court adopted those recommendations, and as it applies to the parenting plan, Ms. Almasquita drafted a proposed order including most but not all of those items that were recommended. And let me just double check to see if if Mr. Miller, if you received a copy of Ms. Almasquita's proposed parenting plan.
Yes, I received a copy, Your Honor.
Okay. And then from your review of things, Mr. Miller, did it comport, did it include everything that the family court investigator had recommended and that the court had adopted?
Yes, I believe the schedule is going to be pretty much the same for Thursdays, and then the allowed 6 hours for Saturday, I think, is the day she decided she wanted.
Okay. So Ms. Amasquita, looking at that proposed order that you submitted, they have Thursdays and Fridays, 4:30 to 6:30 p.m. and then Saturdays, it says some Saturdays up to 6 hours. Is it some Saturdays or every Saturday?
Some Saturdays. It just depends on like what's going on.
With your schedule?
Yeah, or his.
Okay. One thing that I didn't note that was included that I think was part of the recommendations of Ms. Schaefer, and Ms. Schaefer's here on the line. She can correct me if I'm amiss. That there was a recommendation of that there be no introduction of significant others or romantic interest until there's been at least 6 months of consecutive dating, and that there was also a requirement of no disparagement of either party or their significant other, and that there was an indication that it was okay to bring the youngest child to the visit. That was not included in the proposed order, and that any visits outside of the Kelso Longview area would need approval by Mr. Miller and 24 hours in advance notice of the same. Ms. Amasquita, did you include those in the proposed order, and maybe I just missed it?
Oh, no, I did not.
Okay.
But yeah.
Okay. And Ms. Schaefer, anything that did you get a copy of the proposed parenting plan?
No, Your Honor, I did not. I was actually just looking at Odyssey so I could review it, and I can't see it in there either, so no.
Right. So I'll just review it for your edification. There's no 191 factors listed. It shows a limitation on Ms. Amasquita that she's to have limited contact as follows, and it lists Thursdays, Fridays, 4:30 p.m. to 6:30 p.m., and then it states some Saturdays up to 6 hours. It states that it says joint decision-making for school and educational pursuits, health, non-emergent healthcare, and also religion was marked. There's no reasons for limiting to major decision-making, that there would be dispute resolution would be go to court, that the custodian is Mr. Miller, and that limited schedule only, the children would live with Mr. Miller and have no contact with the other parent except as described in section 4, which is a Thursday, Friday, and some Saturdays. And so then section 8 is completely blank. Section 9 is blank for summer schedule, holiday schedule is blank because of just those limitations. And then transportation, there'd be pickup and drop off at the courthouse. And then both would be responsible for doing the dropping off. And then that's it. So with that, just that brief review, Ms. Schaefer, any concerns other than those ones that I mentioned of those omissions?
Is there any concerns or recognition that Mr. Chaddock, her significant other, is not to be in the vicinity and that those visitations are supposed to be in the public? Because I mean, that was my general concern, and that was backing up Dad's concerns as well. And that might be a little vague, and that might not be being mentioned.
Right, yeah, the recommendation was that he not be present or in the vicinity of any visit under any circumstances.
Correct.
Okay. Mr. Miller, any concerns if I were to include that along with the Kelso Longview restriction, no disparagement, and no introduction of romantic interests?
Right. All that sounds fine to me. As long as it's in writing and is put in the parenting plan, then it sounds fine.
Okay, thanks. Ms. Amasquita, any input on the inclusion of those items?
No, that's fine.
Okay, so what I'll do, I'll include language related to it. It's okay to bring the youngest child to the visitation by mother, and that any visits outside of Kelso and Longview need to have approval by the father, and it has to be given at least in 24 hours advance notice, and that Mr. Chaddock shall not be present or in the vicinity of any visit under any circumstances, and that no significant others or romantic interest would be introduced to the children until 6 months of consecutive dating, and that there shall be no disparagement of either party or their significant other.
So I'll include that in the parenting plan and then sign off on it. And is it so any questions about that? Okay.
No.
Your Honor, can we just clarify that Angel has two younger children, not just one younger child, so she can bring both younger children?
Great correction. Thank you.
Thank you.
Youngest children. Yep, I'll do that. So I'll go ahead and sign off on that. And if either party needs a copy of it, you can check with the clerk's office and get a copy for your records. Any final items from any of the parties?
No, Your Honor.
No.
All right, very good. I'll make those changes and pardon me, those additions, and we'll file that today. Thanks everybody for your assistance.
Thank you.
Okay. Thank you.
That was the last time this case was in court. They've been using the same parenting plan that we just watched them agree to for the last 15 months. Mom has unsupervised time with her son again, but she's not able to take him to her home or have him around her fiancé. I do wonder if these continued restrictions on her custody time led to any resentment or difficulties in their romantic relationship. My guess is that it did cause problems between them because only 8 months after Mom agreed to the parenting plan in this case, she filed for a restraining order and a parenting plan against Mr. Chaddick. I don't think this was the only reason for their split, not by a long shot, but I do think it may have been the final straw for Mom. As far as the restraining order case is concerned, it took them 9 hearings over a 3-month period to come to a resolution. Mom was denied a DVRO against Mr. Chaddick. I don't know what sort of allegations she made in that case, but considering the evidence shared about him during the trial, it's not shocking that she tried to get one for herself. As for their custody case, they've only had 1 hearing so far where it seems that the case was transferred to mandatory mediation. There have been no other entries in Odyssey, but it's only been a couple of months. So far, there's no indication that they've scheduled their MSC yet, and there haven't been any temporary orders entered. It's really hard to say what's currently happening with custody. And finally, we have Dad's divorce with his second wife, Nicole. They've not had any review hearings in the case. Instead, the case starts with a short trial setting hearing on January 29th, 2025, to set a date for an MSC. I do have a copy of that hearing.
Number 3 on the docket, 23-3-20-08, Miller v. Miller. We have Mr. Sandy. I don't see Miss Holder.
And I got information that her internet is down and she's trying to log in.
Okay,
So
here she is. Just a second. Miss Holder, are you there?
Yes, Your Honor, I apologize. I didn't have any internet in my office for a few minutes there.
No problem. I just called Miller v. Miller.
Yes.
Just to set an MSC. Counsel, how soon are you looking to have that?
So I have actually filed a notice of intent to withdraw, so I am representing my client at this hearing, but I'm not going to be counsel of record going forward. I have been informed by my client that his best availability is on, I believe it's going to be on Mondays and Tuesdays. So I know that MSCs happen on Mondays, so I would just ask to allow him a little bit of extra time since he will be representing himself pro se if he doesn't find counsel.
All right, Mr. Sandy?
That's fine. How's May 5th?
I believe that'll be enough time for my client to adequately prepare.
So we could do May 5th at 1 o'clock.
That's fine.
Okay.
Right, thank you, Your Honor. I guess that works for my client as well.
All right, thank you.
From what we learned during that hearing, it looks like they went into the MSC with Mom scheduled to be represented by Mr. Zandy and Dad acting pro se. They did end up having their MSC on May 5th, but they did not come to an agreement, meaning that the case now needs to be set for trial. On May 21st, they had a trial setting hearing where the trial was set to the week of October 20th, 2025. I don't have a copy of that hearing, though. They also set a readiness hearing on October 14th. That hearing is one I do have, so let's take a look.
Right, I have number 3 on the docket, Miller versus Miller, 23-3-000-2008.
Morning, Your Honor.
Morning, Miss Holder. And let's see. Do we have Nicole Miller present? And I don't see that she's represented. Is that correct, Ms. Holder?
That's correct. She's pro se. I was either going to strike trial or set trial over. I think the parties are close to resolution. That might be why Ms. Miller's not here today. If the court, it sounds like the court isn't able to do trial next week anyway. And so this would be convenient for, I think, both the court and for the parties. If the court could advise us to setting out trial just as a backstop date, that would be appreciated.
All right. We could accommodate a 1-day trial, but if you're close to resolution, I am happy to give an opportunity for that to potentially occur. I can strike the trial set for next week. I can set it on for trial assignment next Wednesday, the 22nd.
That would be appreciated.
All right. So striking the trial for next week, we will add this matter to October 22nd, 2025 at 9 a.m. for trial assignment. And hopefully you can resolve it short of trial.
All right. Thank you, Your Honor.
Thank you.
So we learned that Mom no longer has Mr. Zandy as her lawyer. She's the pro se one now, and Dad has attorney Holder representing him again. She mentions that their upcoming trial needed to be canceled, and she thought that they soon may have an agreement. But in the meantime, the judge has scheduled them for another trial setting hearing. We can watch this one last hearing too.
Number 2 on the docket, 23-3-20-08, Miller v. Miller. Do we have Nicole Miller? Do we have Nicole Miller? I do not see. We have Mr. Lawrence and we have Ms. Holder. Ms. Holder, any idea where Ms. Miller might be?
I am not sure, but I did communicate with her yesterday to let her know that we had a hearing today. She indicated she was okay. She gave me some dates that she would be unavailable. And so she's okay with me being here setting this trial without her.
Okay. All right. So how soon are you thinking?
As soon as we can after the new year. I believe the parties are ready to settle this matter, but if we could choose a date somewhere, maybe February or March, that would be good.
And are you talking about a day or how long?
1 day.
1 day. Okay. Let's see what we have.
How about the week of February 9th?
I believe that will work. I don't have anything on my calendar, and that was not a blacked out date for Ms. Miller.
Mr. Lawrence?
For me too.
Okay. All right.
And then readiness will be February 3rd at 11:30.
And then we need a pretrial, or did you have a pretrial already?
We've already had an MSC.
No, pretrial.
No, we have not had a pretrial.
Okay, let's set pretrial.
January 20th.
January 20th. Are you at 9 or 1?
Should be 9.
Okay, 9. So pretrial will be January 20 at 9 a.m. And that's really for the pro se party to have an opportunity for the court to let them know how a trial goes. Okay.
Yes, Your Honor. Thank you.
Judge Hahn has set their trial for February 9th, 2026, but it sounds like there's a decent chance that they'll avoid a trial by coming to an agreement before then. I think Attorney Holder wants to avoid a trial if she can, and she's doing her best to work with Mom and save her client money. I'll be surprised if they end up going to trial unless someone decides to be really stubborn. I hope everyone's life will settle down now and all of the adults involved will concentrate on putting the children first. Thank you for watching.